afternoon, everybody, and welcome to today's brown bag lunch. If you did bring lunch, feel free to eat it. We are delighted to bring Unmani Sarasvati here. She wears several hats with the law school. She is an alumna of the JD program. She is currently enrolled in the LLM tax program. She is an adjunct professor here at the law school, and we'll keep thinking of new ways to engage her here. And she's here today to talk about collaborative law and what that means, and kind of how her practice has taken form, and we'll talk a bit about opening up your own practice and some of her experiences in that regard as well. In addition to receiving her degrees here, she's received some significant training both in mediation and in collaborative practice, and is a member of multiple bar associations and professional associations dealing with those issues. And so we are excited to have her here to talk about kind of the really interesting and dynamic way she practices law and works with clients, and she'll let you know, I guess, if you want questions throughout or at the end.
Yeah, I'm going to take it with the structure from here.
Okay, great.
Thanks, Suzanne. So, we're going to talk today about consensual dispute resolution processes. And I'm also going to talk to you a little bit about traditional legal processes and how the concepts of how our role as attorneys in those processes gets played out in light of the formation of your own law firm. So, first off, what a consensual dispute resolution attorney does is they have a tendency to focus on process. They have a tendency to try to structure conversations because most of the clients that they're dealing with in a family dispute situation are highly anxious. And so I just want to let you all know today that I welcome questions at any time. My preference would be that this talk be structured as a dialogue, right? So if we were all sitting down in my office together, getting to know each other, I would spend time listening to each of you, give me a little bit of information and tell me your names. We're not going to do that today, but I want you to feel free to think of us as being in a format, again, that's structured as a dialogue. We are going to be talking about how to grow a successful non-traditional practice outside of law school, how to network with experienced attorneys as a recent graduate focused on offering consensual dispute resolution services, and resources for learning how to serve your clients as a non-adversarial attorney. Is there anything else that anybody here would like me to address in our time together today? Get this, it's called an agenda, right? So when a consensual dispute resolution attorney sits down with anybody, right? Just a couple nights ago, I sat down with one of my professors. I was unhappy with my A-. I wanted to chat with him about how that evaluation came out, and I started the discussion by saying, here's my goal for being here. What's your goal for being here? How would you like to structure a conversation today? Do you want to kind of take it from here, Professor? Or would you rather that I ask you questions? And so again, this is good practice to get into, because one of the things about being a consensual dispute resolution attorney has to do with changing from the mindset, right, that we get taught in law school, that we need to be the font of all the answers, that we are ultimately responsible for outcome. That's why it's called representation. And in our talk today and time together, again, I welcome you to let me know if there's anything else you'd like me to address in our hour. Yes?
Internships, maybe?
Internships. Oh.
Or opportunities.
All right. Do you guys mind if I just kind of go right there?
I'm sorry.
No. Like, why not? Again, it's kind of a free flow of information. And here's the other thing. We can all start practicing consensual dispute resolution skills, but you can keep your eye on the clock. And if I don't start addressing what you came here today to talk about, you can raise your hand and say, Professor Sarasvati, by the way, I see that we only have 10 minutes left, and I was really hoping that you were going to be able to talk to us a little bit about X. So today, I'm going to share the responsibility of timekeeping, again, with you, because we're all going to participate in this time together. So just to jump to the idea of internships. One of the things about working in consensual dispute resolution is that it's really a new field. It's a new concept, right? You talk to, like, I go down to the courthouse, I'm filing something, I bump into one of my buds from GGU, which is very, heavy in family law. And hey, and they're like, what are you doing? I didn't know you were still practicing. I said, yes, I have not died. I'm just practicing consensual dispute resolution, which is why you don't see me down here at the courthouse. And one of the things that they'll say occasionally is, consensual dispute resolution, what the heck is that? literally a label that's been developed in only the past, couple years. And under that label, you have collaborative practice. Most litigation attorneys, even in family law right now, I would say the majority, still have not, don't know what collaborative practice is. Maybe that's not fair. I mean, maybe now in 2011, maybe they've heard of it. But if you ask them, what's collaborative practice? I have actually asked a litigation attorney, I went to a brown bag lunch at a courthouse, right? And they said, where have you been? And I said, I've been really busy working with my clients on developing agreements. And they said, oh, you do that, what's that called? And I said, collaborative practice. And they said, oh, you're so lucky. You get the peaceful cases. And that was my moment where, again, could I launch into being Professor Sarasvati and educate them that they were making an enormous assumption about what I do? I chose that, that wasn't the right moment. So I just said, yeah, sure. Bye. So here's the thing. Because of that nature, getting internships in firms that specialize in collaborative practice or facilitative mediation is very challenging, right? People don't want to give up those cases. So that's the number one thing. Number two is attorneys often say that they can't get student observers in the room, that the clients won't put up with it, right? That the clients say, no, I'm going to talk about super private stuff. I'm not going to sit here like I'm in a zoo with an audience looking. Now, I've talked to people who practice all over the world, and there are actually cultures, meaning legal cultures, in which it is normal to have people observe. And even in the civil community, it's pretty normal to have learning, observing people. But right now, right here, in the family law community, it's very difficult to be able to find and be able to look in and have an internship. So if you want to talk to me after the break, I can kind of give you a list and some resources of avenues that you can pursue. Okay. But one of the things that I teach all of my students in my class in the spring is you may want to consider focusing on learning this process. You have a duty to learn this process, an ethical duty to learn this process inside and out, right? This is your 3 years to understand this mindset and skill set. And let me tell you, if what your goal is to actually practice as a non-adversarial attorney, you need to understand this inside and out, or you won't be able to serve your clients who are often dealing with consulting attorneys, right? Which some are adept at consensual dispute resolution themselves, and others, I'd say, are more like this, litigation folks. Right? Did that answer your question enough for now?
Yeah.
Does any question?
So you said that in your example in consensual dispute resolution, you would enter into a dialogue with the client. So how does that differ? How would that differ in a traditional legal process? What would a traditional attorney do?
Well, I want to address that question, and maybe how I could do it best is to talk about the aspects of the legal process that I'm differentiating from what this is. Right? So why don't I start to address your question with, what are we talking about when someone says the traditional legal process, right? Obviously, we all know about litigation, right? You guys have been taking your appellate advocacy, or maybe getting ready for it, or maybe you've gotten through that hoop, right? Many, many people need to have a third party set out and give them their result, right? So when people hire an attorney and say, oh, hey, here's my situation, right? Here's my conflict. I need you to help me. I need you to solve it, right? Then you have 2 third parties, attorneys, who go and they battle it out in front of a judge. But nowadays, how many people actually do that? In family law in particular, right, they say only 5% of cases ever even get to the 2-day hearing phase, right? So what does that tell us as lawyers? If you want to go out and be a family law litigator, I'm going to encourage you as a professor here at this university to go out and be the best you can be. Because there are people that need that service. We need case law, right? We need people to appear in front of the California Supreme Court. It's not that doing traditional advocacy is a bad thing at all. It's a very good thing for the people who need that as a resource. But in family law, to call a spade, right? 95% of cases just end up with an attorney negotiated settlement, which is you and your colleague, you know, just kind of figuring out what makes sense, right? Now, some traditional attorneys I talk to say, I am versed in the notions of consensual dispute resolution because look at how many settlements I negotiated, right? And when they say that, depending on kind of the appropriateness of my response in the moment, sometimes I'll just be like, okay, because again, I'm not here to teach the world, and if they don't want to know, they don't want to know. But sometimes I'll ask them, well, would you like me to differentiate a little bit between what you do in creating attorney negotiated settlements and what I do as a consensual dispute resolution attorney?
Yeah.
And then last but not least, in the traditional legal processes is alternative dispute resolution. So a lot of people that practice ADR have a tendency to say, you know what, I do exactly what you do. We're the alternative, right? Let's add to this list collaborative practice and facilitative mediation, right? And let's chuck it all together about what our ethical responsibility is and what we do as attorneys. But there is a view that that is not a correct representation, which is why I did the visual on the board, right? Which has this notion that there is, we could just use a metaphor, call this a river. There's a huge river. There's two different worlds, two different hemispheres between acting as an attorney in a traditional legal process, even if that's evaluative mediation, right? Even if that's arbitration, private judging, that there's an enormous, entire paradigm shift that a legal professional, that an attorney needs to make to practice here, right? So what this is in a nutshell, collaborative practice is a non-adversarial process where the people, that has two qualities that are most important to remember. And it's what defines collaborative practice around the world, right? One is the attorneys have a withdrawal clause, which means when I sign with my clients, we're in a collaborative practice process, that's what the agreement is, and we sign the collaborative agreement and file that stipulation, letting the courts know, oh, hey, by the way, we've opted out of the traditional legal process. We're on the other side of the river. We're doing something totally different. Just to let you know, Judge, is that all right? Judge will sign a stipulation in order in most jurisdictions. When we sign that, what that stipulation in order contains is a provision which says, you know what, if this case can't be resolved by the people themselves, and how does it get resolved by them themselves? Them saying, you know what, that agreement's acceptable to me. I'm okay with that. That's resolution in this framework. And if the parties don't do that, well, then they go back here, right, for various reasons. Maybe it has to do with emotional capacity. Maybe they're not going to get their best result here. Again, this isn't like, this is the good place and this is the bad place. It's all about where you're going to get your best results. If you're negotiating with someone who has a mental health disorder, maybe you are very well served for being here, right? I have an ex-client that was my third client. I had to open my doors 6 weeks before I met her. And she had a huge impact on my practice because of the personality disorder that she has and what ended up happening between her and her husband and myself with me acting as a mediator when I was quite inexperienced. It's kind of being in the sights of someone with a mental health disorder can be very challenging. So in collaborative practice, you have two attorneys, right, that are trained in collaborative practice. They sign the withdrawal clause, right, that says, if you move to this process, I'm out of here. I'm going to transition you to a professional who does this, because I don't do that, and I can't do that. Now, some litigation attorneys say, you know what, that in its very self means that I'm not going to support collaborative practice as a process. Because what that means is, in a time of crisis, right, they haven't been able to come to agreement, you're just going to bail. And what the consensual dispute resolution attorneys say in response is, are you not respecting the client's ability to be an expert in their own life? If you have educated them on the spectrum of processes that they can choose, if you have given them the pluses and the minuses and everything else, aren't they ultimately responsible for choosing their own process? Again, this